They're not going to do shit. At the end of the day, they can't do shit.
If he thinks we can't do something, if you're going to look at this judge and think I can't do something, young man, you're going to learn a big...
Today we're inside Judge Simpson's courtroom, and this one escalates fast. This guy allegedly cut off his court-ordered tether, and now he's standing in front of the judge asking for his bond to be reinstated. That's a bold move, because when you remove a monitoring device, you're not just breaking a rule, you're violating a direct court condition. Tethers aren't decorative. They're alternatives to jail. They're the court saying, we're trusting you to follow these rules instead of holding you in custody. When someone cuts it off, judges often interpret that as a serious breach of trust. And that's the real issue here. Bond is built on trust. The court releases someone under conditions because it believes they'll comply. A tether violation sends the opposite message. Now, does that automatically mean no second chance? Not always. Judges may look at why it was removed, intentional versus malfunction, how long the person was not compliant, whether they turned themselves in, prior record and history of violations. But let's be honest, walking into court after cutting off a monitoring device and asking for bond back is a steep uphill climb. So what do you think? If someone violates a tether, is that an automatic remand them situation? Or should courts still consider context and give another opportunity? Let's see how Judge Simpson handles it.
Court calls the case of the people versus Marquesi Hankey.
I was letting them speak up. Thank you, Your Honor.
Good afternoon, Your Honor. Attorney Kevin Hassan, P7.
All right, it's your motion.
There's a good probably motion to state that previous PCC hearing, my client's bond vote from privileges from the jail suspended due to allegations that he cut off his tether and contacted the complainant. Following that particular bond hearing, my client not contacted a complainant witness, period, in the jail. Also instructed my client that if allowed to be back on bond, we would ask the court to hopefully reinstate his original bond tether. I would note, Judge, that he has no prior criminal, no prior felony conviction whatsoever. Following the submission of my motion, I did read the people's response, which I guess there's been allegations that my client had contacted the complainant subsequently. Now, I just found out today some transcripts. Obviously, people address this. Some of the language that was used during conversations. I don't have phone conversations myself, but I will admit, Judge, that it seems as if my client had contacted the complainant even after his bond. And so I say this, Judge, again. I know it seems like my client is kind of throwing up his middle finger to the court.
Oh, yeah. He is.
But Judge, I just would state that this young man, I think he understands now that the court orders are serious, that the court orders him to do something it means. So Judge, I'm just asking, I guess, for some leniency to trust that Mr. Hankey will comply. He had a $75,000 cashier refund that he was able to post to a bondsman. The only thing I can ensure that if the court were to give him a second chance, he would not violate his bond, even if the bond is a house arrest with strict conditions. So Judge, I am asking the court to reinstate his bond, and if the court is unwilling to do so, I would at least ask that his phone privileges be allowed back on to at least contact family. Does he's never had any contact with his family, his children? He hasn't been able to contact his dad, caretaker for. So at the very least, the restriction on his phone privileges to contact family.
All right. Well, before I hear from the people, counsel, let me just say, you came in here the first time, and well, let me start with this. Where's our tether?
From my understanding, Judge, I thought Community Corrections still had it. I thought they had become.
He cut the tether off. We haven't seen it.
Okay.
And I know you made the representation to the court, but I know you wouldn't have personally known that. I'm sure that came from your client or something along those lines. We don't have the tether back.
Okay.
Then you know, and I get you're making the representation saying your client's going to follow what the court says, but I don't know if anything can be as shocking as walking into a court free. Your bond gets revoked. You get put in jail because of something that you've done, and then you still go about violating the court's order.
I get why that moment feels surreal, when even the defense attorney is basically acknowledging how it looks. You know the optics aren't great. From a judge's perspective, bond really is built on trust. It's the court saying, you can remain out of custody, but only if you follow these conditions. A tether isn't symbolic. It's one of the strongest supervision tools short of jail. Cutting it off doesn't just violate a technical rule. It signals noncompliance with a direct court order. And judges take that personally in the institutional sense, not emotionally, because their credibility and authority depend on orders being followed. That's why the handshake analogy isn't far off. Bond is conditional freedom. When someone violates it, especially in a deliberate way, courts often see that as evidence that supervision isn't working. But here's the nuance. Judges still look at factors like, was the removal intentional or explained by malfunction? Did the defendant turn themselves in? How long were they off monitoring? Is there a pattern of violations? Is there a public safety concern? If it appears calculated, like someone testing the system, reinstating bond becomes a much tougher sell. Not because the judge is offended, but because the risk assessment shifts. The real legal question isn't, is he arrogant? It's, has he demonstrated he can follow conditions if released again? And once the trust is broken, it's very hard to rebuild in the same case. So here's the bigger issue. Should bond violations automatically mean detention? Or should judges retain flexibility to weigh context? That's where the real debate lives, not in the sarcasm, but in risk versus second chances.
I'll be honest with you, counsel. I mean, I get what you're saying. I don't have a problem giving people chances. I just don't know that this is the one to give a chance to. Because he just hasn't done anything the court's asked him to do. Ms. Senda.
Your Honor, I will rely mostly on emotion. However, in listening to his jail calls, he has 45 total calls to one number after his privileges were revoked with different pins he's using. Then to the other number, we have 23 calls that were completed since his privileges were revoked with different pins. And in one of these calls, as recently as Monday, there were a few memorable quotes that I heard in the calls, such as, "There's not shit in this world that's going to stop me from talking to you, man. Nothing in this world's stopping me from you. I don't give up what nobody says about none of that. I'm going to be calling until my court date. They're not going to do shit. At the end of the day, they can't do shit. I'm going to talk to you till I can't talk to you no more. I'll be home. I'm not worried, man. I know I told you this is about to be my last call, but I'm not stopping shit. I'm not stopping nothing. And then, why stop now if they already know?" So I have extreme concerns that he cannot follow court orders, considering he cut off his tether, continued flagrantly calling the victim with other pins, both numbers, acknowledging in some of the calls that he should not be contacting her, and continue to contact her. He just cannot abide by any of the court orders that are set before him. So I have great concerns, and especially given the violent nature of this case as well.
Anything else, counsel? I mean, counsel, does your client want me to just request to the jail that they put him in solitary so that he has no contact with anyone, can't use their PIN number? If he thinks we can't do something, and if particularly you're going to look at this judge and think I can't do something, young man, you're going to learn a big lesson.
So I definitely don't want that. My client.
Well, he needs to, and I don't mean to interrupt you, counsel, but he needs to understand. You can say all that stuff. You are not that big, not that bad. Now, if you want to play with me, this is the kids say, mess around and find out. I guess that's not the quote, but yeah, it's close, but I did pretty good. I said it okay, right now. All right.
So just if I may, just briefly, my client would like to.
Go ahead.
I want to apologize. I don't think I'm being bad at all. is pregnant by my child. I can't say that I'm not in here for nothing. You know, obviously think I am. Yeah. I just want to apologize. Like I said, I'm not big that. I don't want to be here. I really don't. Truly. But again, please show mercy. Please. Thanks.
I have no problem showing mercy to those that deserve it and have earned it. You have not. Motion for bond reduction or any change is denied. This bond will continue as revoked.
Thank you, Judge. And for the record, this is also, from my understanding, PCC.
Yes, sir. Is all discovery complete?
And I would ask if possible, if possible.
People have their witnesses available on the first.
We'll do our best, Your Honor.
Preliminary examination in person will be set April 1st, 2025, 9 a.m. in person before Judge Perry.
And Your Honor, I did want to make it clear where I did contact the jail yesterday, and they have blocked both of victims' new numbers and old numbers, so there should not be any more
calls coming through. All right. Thank you.
Thank you very much, Judge.
Thank you, Your Honor.
I understand why you feel that way. When someone ignores court orders, keeps contacting a protected person, and then appears dismissive about it, it raises serious red flags. That's not just attitude. That can cross into public safety concerns. From a legal standpoint, this isn't really about whether the apology felt real. Judges don't sentence based on vibes. They look at pattern of behavior. Is this repeated noncompliance? Risk to the alleged victim, especially in no-contact situations, bond violations. Cutting a tether is a major breach. Likelihood of future compliance if someone continues contact after being ordered not to. That's often viewed as escalating behavior. Courts take that extremely seriously because protective orders exist to prevent harm before it happens. That said, jail with no phone calls isn't usually about punishment for arrogance. It's about stopping ongoing violations, protecting the other party, preserving the integrity of the court's authority. If a judge believes the defendant will not comply with release conditions, detention becomes less about anger and more about risk management. The hard truth is this: once someone repeatedly shows they won't follow supervision rules, the court's options narrow quickly. Warnings only work if behavior changes. So the real legal question becomes, has this person demonstrated that community supervision is ineffective? If the answer is yes, detention isn't revenge. It's a consequence tied to demonstrated noncompliance. That's where judges like Judge Simpson draw the line. Not at disrespect, but at danger and repeated disregard for court orders.